Greetings, 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 greetings. I'm King Clifford Jefferson, Senator of God for the Fifth Caravan Jew, son of the folk rule of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ, the Vicar of Christ, or the King of Peace. It is July 20th, 2025, which is equivalent to your Gregorian year, once again, 2025. There's 2975, which is equivalent to your year 2025. I greet you in the name of my Queen, Sister Galveston from the House of Galveston. I greet you in the name of my Archbishop Belmont from the House of Belmont. I greet you in the name of all the ancestors who have came before us, who have stood the test of time, who have been a testimony to what it is that I bring before you as a revealer of the truth. Greetings, Archbishop Belmont from the House of Belmont. Glad you were able to join me today for this marvelous lesson. Once again, I just want to let you all know that it is a beautiful day to be here today, to be able to break bread with my brothers and sisters, and to let them know that I am the one and only to be able to reveal those truths that you seek that apparently you have not been able to understand. I don't know why that is. It probably is the result of your environment. We know in our environment, we must change three things: people, places, and things. If you don't do that, there will be no change. Today's lesson is called Understanding America's Revolution. It's the breaking of our slavery in America. It's the key to the breaking of our slavery in America. Once again, I have to correct the title. Understanding America's Revolution is the key to breaking our slavery in America. When I say our slavery, I'm speaking inclusively and exclusively about a group of people misnomer as Negro, Black, Colored, and Ethiopian. Okay, it's very important that when you watch this video, as the title is fitting, understanding the American Revolution is the key to the breaking of our slavery in America. Without further ado, let's get started with this marvelous lesson. Once again, greetings, Archbishop Belmont from the House of Belmont. Glad you was able to be here to be able to moderate tonight. It's going to be a good one. Once again, I'm just thankful that I'm in a position that many have the ability to be in, but choose not to. To be able to reveal certain truth about people that the people should know. So today I'm going to speak calm. I'm going to speak clear. And I'm going to speak direct. There's so much information out there on YouTube, Wikipedia, all those avenues that people search for the truth, whether it's dealing with politics, religion, finances, spirituality, afterlife. Take your pick. I'm very thankful. One second. that are important. Once again, I lost my train of thought, but I'm gonna pick off where I left off. I'm just thankful that someone has developed enough courage, even in a time where people don't appreciate a message. When family, your friends, your boys, girlfriend, children, pretty much doing what they want to do. And we lost our way. I'm glad that for all the things that one can wish for in a life that's bestowed upon them, or a life that they wish they had, I wouldn't change nothing, because that life and the life I wish I had, I've seen it. I've witnessed it as a result of my ancestors. It's pretty much what was promised in the biblical stories to the children of God, known as the Hebrews, when God told them that as a result of their disobedience, they were expelled from their land. And when they come into the fullness of God and decided to become obedient, that there was a promise from God that one day his children's ancestors, the ones that were not rebellious, will one day break those chains of the unconsciousness about the promise that God intended for them to have. That's been a long promise. That's been promised for a long time. We know time is measured by a cycle of ages. Time never was when man was not. As the life of time began, the time would come when man and his offspring will be no more. So I'm thankful for me, and I'm thankful for you. I'm thankful for us, because the Creator chose one of us to bring us out of darkness into this marvelous light. And he couldn't have picked a better time to do it. Trump is mentioned twice in the Bible, or trumpets. The word trumpet or trump means to be victorious, and everything that's synonymous to that term. So a lot of us, when we read our Bibles and the return of the Messiah, New Jerusalem, the Promised Land, a lot of us are confused and misguided. And they choose to be confused and misguided as a result of choice. It is a choice. It is a choice. So with that, I'm not gonna waste no time. I just want to give another honor to Archbishop Belmont for his hard work here at the Third Temple Church of England and everyone that comes under his tutelage. I've been doing a lot of hard work in these courts for our people, the children of the Kingdom of England. Work that you wouldn't realize. Every day I'm becoming more aware in the stability of the consciousness that's been bestowed upon me. There's a difference between stable and conscious that you learn and not stable and conscious that you learn. There's a big difference. We are here to be tested. We're here to be tested about the things we know, the things we believe, the things that we act on based upon the things we know and the things we believe. And there's only two outcomes to that equation. Either it's truth or it's false. So once again, Brother Nunley, Brother McGarrell, Archbishop Belmont, and everyone who's going to be joining me today, I thank you all sincerely for being patronage, honoring your peerage, standing on your nobility, and not forsaking your forefather. And with that, let's get started. This lesson, or this beautiful contract between the king and the people, should be fully understood. And if you are part or have any affiliation with any type of revolution from your government, that's a form of treason. It is a form of treason, brothers and sisters, to the highest degree. Every government that you have presently, whether it's the United States government on the federal level or the state government, is a government derived from the revolution. It's called a revolutionary republic, a republican form of government. We need to understand these terms that we're associated with. Because as a result of that affiliation, there's two terms come into play. Oath of allegiance and oath of affirmation. And they're not the same. Oath of allegiance and oath of affirmation. They're not the same. If there's an oath of allegiance, there's no need for a revolution. Listen clearly and listen humbly. If there's an oath of allegiance, there's no need for a revolution. If there's an oath of affirmation, then an oath of affirmation is just an agreement between parties that don't have to be based upon some type of allegiance. What's the saying? Enemy of my enemy is an enemy is an enemy. Enemy of my enemy is a friend. So it's very important that you understand people, places, and things when it comes to understanding today's lesson. Understanding America's revolution is the key to the breaking of our slavery in America. It is the key to the breaking of our slavery in America. It's a result of the revolution that you're enslaved, my brothers and sisters. It is a direct result of the revolution that you are in fact enslaved by the agreement of the revolution, which resulted in a pledge of allegiance to the nation, which was not based in an oath of allegiance. It was based on an oath of affirmation. You must understand the difference. Let's see. Affirmation. It's on Wikipedia. According to law, everybody hold that thought. Okay, affirmation law. In law, an affirmation is a solemn declaration allowed to those who consciously object to taking an oath of allegiance. Okay? In law, an affirmation is a solemn declaration allowed to those who conscientiously object to taking a oath. Very important to understand the difference between an oath of affirmation and an oath of allegiance. Okay? Oath of allegiance in the United States. Everybody needs to write these terms down. I said there's a difference between oath of affirmation and an oath of allegiance. There's a difference. In the United States, the oath of allegiance and the oath of affirmation means the same. But for us, as subjects, which you call citizens of England, an oath of allegiance and an oath of affirmation is not the same. Okay? Very important you make that distinction. Okay? Oath of allegiance in the United States. The oath of allegiance of the United States is the official oath of allegiance that must be taken and subscribed by every immigrant who wishes to become a United States citizen. It said every immigrant. It didn't say every citizen, because every citizen takes the oath of allegiance based upon the country and the nationality and your allegiance to the country and the national laws based upon the governing political body, which is under a monarch, according to us and our body of politics. Okay? Very important you understand that. The oath of allegiance in the United States is the official oath of the allegiance to what? The United States. But there's nowhere in the 1776 Constitution do they mention the word allegiance. It did in the proprietary colonies or in the colonies now called states. But when they became the states, when they declared their independence in 1776, there's nothing in there about an allegiance. There's something in about a oath of affirmation to the oath of office, which is totally different. Okay, this is what we're going to talk about today. So the oath of allegiance of the United States is the official oath of allegiance that must be taken and subscribed by every immigrant who wishes to become a United States citizen, not a citizen who was here before the United States existed. Because prior to that, we did not call ourselves citizens. Okay, we were subjects under the kingdom of Great Britain or Britain, not the kingdom of Great Britain, because Great Britain didn't come into existence through the unification of the three realms, England, Ireland, and Scotland in 1707. That's very important that you understand that. The oath may be administered by an immigration judge or any authorized officer of the United States, citizenship and immigration services, including by any eligible federal judge. This must be understood in regards to your proper understanding of a oath of allegiance of the Kingdom of England or any other foreign country that's not the United States versus a oath of affirmation, which is nothing more than something on an alternative to a oath of allegiance, which is nothing more than a pledge of allegiance to the flag of the United States, which you became an immigrant, naturalized citizen under title, what is it? Title 49 says Code Section 1801. I could be wrong with that statute, but don't quote me. Okay? All right, let's get on with it. We have affirmation of law, then we have the oath of allegiance, which is pretty much the same thing, an affirmation of law. They don't give an oath of allegiance to the law, but they want you to pledge an allegiance to the flag of the government that they created, which is now based upon an allegiance to the government that they created, because they know they had a prior contractual agreement that was based upon allegiance. And what country was that? Great Britain. Not the Kingdom of Great Britain, but Great Britain, which was England. Okay? The Kingdom of England specifically and inclusively talking about Great Britain. Not Ireland, not Scotland. Okay? We must make this clear. Pledge of Allegiance. United States Pledge of Allegiance. The United States Pledge of Allegiance is a patriotic recited verse that promises allegiance to the flag of the United States and the Republic of the United States. Once again, this is all linked together, going all the way back to the Republic Revolution. Once again, the Republican Revolution. All revolutions are what you now call a republic or a commonwealth, which started with the glorious revolution. Everyone hold that thought. right? United States Pledge of Allegiance. These are basic understandings that we must understand to overstand what our allegiance is to. Okay? We know what a pledge is, right? When you pledge something, you give something away. All right? When you pledge something, you give something away. United States Pledge of Allegiance, when we say the United States, we're talking about the original 13 colonies, okay? As a result of the revolution. The 13 colonies was a result of the Declaration of Independence, which is what they call a revolution. We must not lose sight of these terms. When we have a revolution, it automatically results in what you call a civil war. You're not that far from it today, my brothers and sisters. You're not far from a civil war because the civil war results in what we call rebellion. Rebellion. Rebellion, everyone. The United States Pledge of Allegiance is patriotic recited verse that promised allegiance to the flag of the states and the Republic of the United States. Once again, United States Pledge of an Allegiance is a patriotic recited verse that promises allegiance to the flag of the United States. So when you become a United States citizen, you're obligated to take an oath of allegiance to the United States flag, which is called an oath of allegiance. Okay? An oath of allegiance. All right? And we know an oath of allegiance of the United States is the official oath of allegiance that must be taken and subscribed by every immigrant who wishes to become a United States citizen. It didn't say nothing about those citizens who were born on the soil. Okay? Those who were born on the soil. Born on the soil. Okay? They're talking about those who immigrated here. All right? Those being immigrated and then born on the soil, that question comes up later. All right. We're talking about a oath of allegiance to United States citizens by way of naturalization as a result of them immigrating here for a certain amount of time and then taking an oath of allegiance, which means that when you take the oath of allegiance to this flag, you give up your allegiance to your nation country, which makes you a treason. You have committed treasonous act. You have committed a treasonous act. Okay? If you don't have a country, then it's not a treasonous act. Okay? You gotta go, you gotta come from somewhere. If you don't come from somewhere, then you have the right to request to belong to some country. Okay? Very important. Now that we understand the difference between affirmation of law or an oath of affirmation, which is nothing more than an oath of allegiance or a pledge of allegiance to the United States and the United States flags, the United States government, the United States laws, the United States agencies, state agencies, everything has to do with the state, their government, their agencies, their departments, their citizens, their residents, etc. If everyone understands that who's here tonight, please give me a thumbs up in the chat line to make sure that we're on the same wavelength. Please. Now we're going to look at a oath of allegiance from the English standpoint or from the English perspective, according to the English laws, according to the English presidents, according to the English custom. Everything's associated with the English law. Okay? If you understand the importance of a oath of allegiance, not from the perspective of how the United States perceive it, or not from the perspective of how the states perceived it, or not from the perspective of any other country that makes laws govern how their make laws govern their immigration and foreign or national policies. We're making sure that since we are under the law under the laws of the English people, that we prescribe to the English law, govern our right to be on any land governed by the English people who made those laws for those who would later descend from them in regards to that allegiance, all right, in regards to what they're taking allegiance to, which they're obligated to because it's a protected right. Okay? It's a protected right. Okay. Oath of allegiance from the English understanding of what allegiance is meant, and the oath to the allegiance of why it was passed down from your ancestral predecessorial descendants. Okay? A oath of allegiance. And just the basic understanding, all right, of an oath of allegiance. Oath of allegiance is the oath whereby a subject or a citizen, a subject or a citizen. We're not talking about officers. We're not talking about members. We're not talking about wannabes. We're talking about subjects or citizens who are not immigrants, okay? So the allegiance for us is different. 1 second, everyone. Okay, oath of allegiance with the proper understanding, okay? Because we see there's a different understanding for immigrants, okay, who are not citizens or subjects, okay? Because the allegiance for an immigrant is nothing more than an oath or affirmation that you're going to go based upon the agreement, okay? All right? It has nothing to do with your allegiance, okay? Allegiance is not a contractual thing, all right? Allegiance is not a contractual thing. You don't have the option of saying no, okay? It's either death or duty for us. Give me liberty or give me death. Give me freedom or I stay in chains. The oath of allegiance is the oath whereby a subject or a citizen acknowledges a duty. You hear that? It's a duty. It's a necessity. It's unmendable. It's non-negotiable. All right. An oath of affirmation is negotiable. You can say, I quit. I'm not gonna take oath to that. You know what I'm saying? I don't believe the oath is to my terms. Okay. Contractual agreement. All right. It has nothing to do with that. It's talking about an allegiance acknowledges a duty of an allegiance and swears loyalty, a duty of swears loyalty to the monarch or a country. You hear that? Swears loyalty to the monarch or country. The parent patriarch, the fathers or the father of the nation. Okay. Father's Day, June 15th in 2975, which will be in your year 2025, was the year of the Magna Carta, where our ancestors were forced to sign the Magna Carta as a result of feudal land barons who ignore the allegiance and the oath to support your king in good times and bad times, through thick and thin. Okay? Do right and wrong. Because sometimes you got to do things, whether it seems wrong, to make it right. Okay? It's called a necessity. All right? Justification for your action. There's a right. I wouldn't say a right. There's a justification for a revolution. All right? There comes a time for justification for a revolution. What justifies a revolution? Okay? What declares a revolution is a justification for a revolution for the people to ignore the laws, the customs, the traditions of what it is that they take an oath or allegiance or affirmation to. Okay? I'm going as slow as I can. An oath of allegiance is an oath whereby a subject or a citizen, as in say an immigrant. Immigrants don't take oath of allegiance. Immigrants take oath of affirmation. We just read it in Wikipedia, brothers and sisters. In Wikipedia, we just read that citizens take oath of allegiance. Citizens don't take oath of affirmation. If they're telling you that an oath of affirmation is the oath of allegiance, then they're lying to you. Okay? An oath of allegiance is the oath whereby a subject or a citizen acknowledges that they have a duty of allegiance and swear loyalty to the monarch or a country. Okay, not the country that they come from if they're taking an oath of affirmation. But if you're taking an oath of allegiance, it is the country you come from and the monarch of the province patriarch who's running the country. Okay, in this case, you're talking about the president, which does not take no oath of allegiance. He takes the oath of affirmation. It's right there in your 1776 Constitution, Article 23. We're going to read it from the record. In modern republics, oaths are sworn to the country in general or to the country's constitution. Okay? Or to the country's constitution. We know the constitution is the charter. We know the charter governs their corporate powers, and all corporate powers derive their authority from their sovereign grant. And we know that's usually from the state in which they are incorporated based upon the state laws and where that corporation or that entity came into existence. Okay? So, for example, officials in the United States take an oath of office that includes swearing allegiance to the United States Constitution. However, typically in a constitutional monarchy, such as the UK or the Kingdom of Great Britain, or Great Britain, or just Britain, or just England, and etc., and other Commonwealth realms, we know Commonwealth realms are republics. Oaths are sworn to the monarch armed forces typically require a military oath, and our time they're called knights in services. Okay? Very important that we comprehend. In feudal times, a person will also swear allegiance to their feudal superior. These are called not legal lords. These are called landlords, lords of the manors, manage lord, or simply landlord. To this day, the oath sworn by freemen, also the same word can be also termed freeholder or what they call commissioner. All right, same word. Oaths of allegiance are commonly required of newly naturalized citizens. See oaths of citizenship, which we just recently read. Members of the armed forces and those assuming public, particularly parliamentary and judicial offices, clergy in the Church of England are required to take an oath of supremacy, acknowledging the authority of the British monarch. Once again, it goes back to the original understanding of oaths of an allegiance. Okay, so with that in mind, we now come here. The Kingdom of England, just a brief understanding about the Kingdom of England, called Great Britain. Okay, once again, the Kingdom of England, also called Great Britain, which is called a radical title of the king and all the possessions that belong to the king, known as Crown Land, under the authority of the Crown of Great Britain. Okay, when we say the Crown of Great Britain, we're not talking about the land itself. We're talking about the political body of politics, which we call an itinerant court, because wherever the government goes, the territory where the laws of that government govern. Okay? This is called an itinerant court. We know that there was no unification to the Kingdom of Great Britain until the Treaty of Union in 1707. Prior to that, England, Scotland, and Ireland were separate rims. Okay? They were separate rims. This is the basic understanding. Okay? Let's look at a radical title. Everyone should be writing these terms down. All this determines your right to the estate and land. When I say estate and land, I'm not talking about an estate and real estate. I'm talking about an estate and land. All right, you talk there in the more Central America, they call parcel estates or partial estates. Okay, estates and land. Allodial to what we call charters called bookland. Okay, bookland. Radical titles is a concept in English common law that refers to the crown's underlying title. Okay, meaning that the crown has a right to reversion and remandment based upon laws that govern crown land, and we know the ultimate sayer of that is the king, because the king personifies the crown, and that land which the king personifies, the land is inseparable from it. Okay, this when you come into what we call it's called uh it's called land conveyance. Okay, it's land conveyance. You have land conveyance where land is conveyed to you or given versus land that is taken. Okay, by force. All right. Radical title is a concept in English common law that refers to the crown's underlying, meaning the crown has an equitable interest in the title. Okay, we know title is the proof and the evidence and the right of possession. Okay, possession doesn't prove ownership. It means a interest in the possession of the underlying property in question. It does not prove ownership. Why? Because the crown has an underlying interest in it to all land. It didn't say real estate. Okay, it said an estate, whether it's a separate estate or if it's called the allodial estate. The crown has a underlying interest in it. There are now called overseas plantations and colonies. Okay, overseas plantations and colonies. Why? Because as I stated before, when we're talking about uh, talking about Great Britain, we're not talking about land. We're talking about the body of politics that governs that land that they assume is called Great Britain. Not the Kingdom of England, not the United Kingdom, but Great Britain concerning the body of politics. The body of politics, as we know, is based upon only two: soul and aggregate. Okay, and we know that corporate authority or corporate powers derive their authority from what? The sovereign grant. That's usually derived from what? The statutory laws or the legislative laws where that entity came into existence. Okay? Before that entity called a corporation, okay, came into existence, it had to use some law that was already into existence to to give it some type of of of, of existence. Okay, hold that thought. Overseas possessions. All right, very important. I'm going very slow. Even a snail can follow me. If a snail can follow and keep up with me, then why can't you? Okay? Why can't you? English overseas possessions under the kings or the monarchs or the crowns, which are synonymous, radical title. Okay? All these terms we just discussed, so they should flow fluently, just like water. Okay? Just like water, okay? Whether the water is moving fast or the water moving slow. If the water is moving fast, it's impossible to intake that water because 9 times out of 10, you would drown, okay? So this life-giving water, I have to slow it down because if I speed it up, you would drown, okay? And we know if you drown, then there will be need for drinking water, okay? Water is to give you life, not to kill you, okay? English overseas possessions comprised of varieties of overseas territories that were colonized. When it was colonized, then you're talking about immigrants, okay? Whether those immigrants came over there and asked to be there, or they came over there by force, we call that conquered. In not modern terms, they call that eminent domain power, or what we call inquisition post mortem, or we also call that compulsory purchase by what we call prescription of sovereignty by somebody claiming to be the sovereign, but have not yet proven that they are in fact the sovereign over here. Because we see that when we're dealing with Great Britain, Great Britain only concerns the Kingdom of England and all the colonies, overseas possessions that are over under the authority of the King's radical title called Crown Land. which was a part of the Kingdom of England before 1707. Okay? Under the authority of the Act of Union, which made England a part of the new Kingdom of England, now today called what? Everybody said the British Empire. Okay, if everyone understands that, based upon this water that you're drinking, can I get a please thumbs up in the chat line? Please give me a thumbs up in the chat line. I'm trying to go slow for you. I don't know if I can go any slower, because if I go any slower, the water would evaporate, and that would defeat the purpose. Now we're talking about the Kingdom of England, called Great Britain, all right? Going all the way back to time immemorial, which comprised of the English overseas possession under the King's radical title, called Crown Land, okay, under the authority of the monarch who personifies the crown. We know based upon Chisholm versus Georgia, there are only two type of body politics, corporate and aggregate. Okay? Very important. Thank you, Brother Nunnally and Brother McGarrow. Knights of the Shires, Knights of their specific counties. As we can see from the first paragraph, okay, Archbishop there as well. We're reading from Wikipedia concerning Great Britain of the Kingdom of England, also called Britain or Albion. Okay. The Kingdom of England was the sovereign state on the island of Great Britain. That would mean any island that you want to call Great Britain. They're not specific about what island called Great Britain, but they're talking about an island in Great Britain. From the 9th century, when it was unified, a varied Anglo-Saxon barbarous tribes known as Northwestern, Middle Eastern, North African, for lack of a better term. Okay? The Kingdom of England, before Scotland and Ireland and Great Britain and the United Kingdom even became into the picture, and before the territories known as Great Britain or United Kingdom was even thought of, we're talking about a body of politics, wherever they were that, which was operating from the 10th century on. Okay? The Kingdom of England was a sovereign. We know what the word sovereign is, right? We ain't talking about an individual. We're talking about the body of politics governing the land. And without the land and without the body of politics, people would not be able to be there because there would be nothing but straight chaos. So from the 9th century, we can validate, based upon the record, a unification of tribe and people that was not unified became known as the Kings of Wessex, which were composed of Anglo-Saxon kingdom, okay? Until 1707, when all of a sudden the Kingdom of Scotland came in the picture and now called it a Kingdom of Great Britain. You see how simple that sounds? Which will later now be called United Kingdom. Okay? Prior to that conquest, prior to that immigration, there was the only language at that time they were speaking was English. Not Old English, not Germanic. The only language that we're speaking is the same language we're speaking today, which you call the Latin language, because we have legislation passed by the Plantagenet King Edward I called the Pleading Act in 1362 or 1367, which said that as a result of the Norman conquest, which brought in Norman and French languages, there was a mandate legislatively implemented in regards to when you're dealing with anything in regards to law or courts of law, which calls the assize court, that the only language that will be spoken like it's spoken today is English. Okay? It's English. This is called the Pleading Act of 1362. Okay? The Pleading Act of 1362. I thought I read that. Give me a second. Right here. I had it right. I've been on here an hour. Pleading in English Act of 1362. This is the 14th century, my brothers and sisters. This is the legislative law or the legislative statute. We call these reception statutes, okay? They're called reception statutes. One second. These are called reception statutes, which were acts passed by the Parliament of England, whether you want to call it the Parliament of Great Britain or the Parliament of England or the Parliament of Britain or the Parliament of Albion. The same laws were passed down and conveyed, okay, successively. All right. It clearly says that the act complained that because of the Norman French languages, when we talk about Norman French, we're talking about William the Conqueror, we're talking about French, we're talking about Spanish, Roman Catholic influences on the language of the court. Okay? All right? It says that the act complained that because of the Norman French languages, based upon the Norman landowners, which are based upon the Norman barons, okay, i.e., knights, okay, of the Norman kingdom called feudal barons. That goes back to the charter that was forced upon John of the Plantagenet kingdom, was largely unknown to the common people of England or Great Britain or Britain. They had no knowledge of what was being said for or against them in the courts. When we say courts, we're not just talking about the courts of the county or the shire. We're talking about just the language in general. Okay, this is general language for us. Okay, which was used in law in French. The act therefore stipulated, mandated that all pleas which shall be pleaded, when you go to court, you plead in any court whatsoever, all right, whether you're in the court of law, in the court of the county, or the court of the county, and the court of the shire, and the court of the county, all right, or the court of the hundred, all right, which is another term for them, it must be in English before any of the courts of justices whatsoever, or in his other places, or before any of his other ministers whatsoever, or in the courts and places of any other laws whatsoever within this realm, shall be pleaded, sued, defended, answered, debated, and judged in the English language, and that they be entered and enrolled in what? Latin. The Latin letters are the English letters, my brothers and sisters. This goes all the way back to the 14th century. A English king, which was a Berber king. All right, very important that we comprehend that. Let's go back to where we left off. Kingdom of England. All right. Beginning in the year 886, Alfred the Great reoccupied London from the Danish Vikings. These are the Nordic and French descendant. Kasai. Shh, I'm on the phone. I'm doing the lecture. Beginning in the year 886, Alfred the Great reoccupied London from the Danish Vikings. And this event, uh, he declared himself king of the Anglo-Saxon until his death in 889. During the course of the early 10th century, the various Anglo-Saxon kingdoms were united by Alfred's descendants and Edward the Elder reign and Asterton reign to form, pardon, so to form we're just revisiting history. History of the Kingdom of England from the Norman conquest of 1066 conventionally distinguished periods named after successor ruling dynasties. Norman Angevin, Plantagenet, Tudor, Stuart, interrupted by an interregnum. An interregnum is what you call a revolution. Once again, an interregnum is what you call a revolution or a civil war. At this time, it was called the Glorious Revolutions or the War of the Three Kingdoms. All English monarchs after 1066 ultimately descend from the Normans. Did everyone hear that? All English monarchs after 1066 ultimately descended down from the Normans, and the distinction of the Plantagenets is conventional, beginning with Henry II, son of Godfrey the fifth Caliban Jew, the son of Folk, the ruler of Jerusalem. Okay? We must understand that we have an allegiance to our ancestors, okay, based upon our allegiance to the king and country, which they took an allegiance to based upon their oath, not just allegiance, but oath of affirmation to the tenure that they hold. Okay, so the Normans, William the Conqueror, and they invaded England in 1066, all right, which brought forth the birth of the Plantagenet dynasty, which were kindred to the kings of Wessex, which their descendant Tudor from the House of Lancaster gave an existence to the House of Stuart as a result of the conflict that was internally brewing, which is called the Hundred-Year War, the War of the Roses, the Castilian War, the Albicelsian War, and a lot more that spiraled out of control, which resulted in the conditions that we're in right now. Okay, very important that we understand that. All right. Also, Great Britain. So we know the Kingdom of England, Great Britain are one and the same under the radical title of the King. With that being said, that takes me to the United States versus United versus Late. We're talking about title to property. When we say property, we're not talking about real estate. We're talking about the estate. Okay? Hold that thought. Okay. So it said in all cases, when title property came into controversy between the crown and a subject, whether held in right of the person who was the king or as a representative of the nation, the petition of right presented a judicial remedy. This is what we're just talking about. Pleas to the crown. Just talking about that. A remedy which this court, on full examination in a case which required it, held it to be practical and efficient. There had been therefore no necessity, you hear that, for showing the officers or servants of the king who held possession of such property when the issue could be made with the king himself as a defendant. Okay? This also put me in mind of Chisholm versus Georgia. Two, another reason of much greater weight is found in the vast differences in the essential character, they're talking about the body of politics, of the two governments as regard to the source and depository of the power. Once again, we say Great Britain, we're talking about the difference in the body of politics of those kings and their government reside in what you call Great Britain, because they was over there and it was always over here as well. Okay? So we have to determine where they were and who was running that government wherever they were, whether they were over there in what they now call UK or the Kingdom of Great Britain or what we call Great Britain or the Kingdom of England, which is right here. Okay? Very important. Notwithstanding the progress which had been made since the days of the Stuarts in stripping the crown of its powers and prerogatives. You hear that? So that means that the House of Stuarts stripped the crown, not the British crown, not the Irish crown, but of course the crown of Great Britain. The same Great Britain that you mentioned in Article 32 of New Jersey, which we're going to talk about in a second, because at this time you didn't have the Kingdom of Great Britain because that unity didn't come till 1707. So notwithstanding the progress of the revolution that took place at that time called a interregnum, which we now call a commonwealth or republic, or what we call a revolutionary republic. So with that in mind, let's go to the word revolution. Okay? Let's go to the word revolution. Right to a revolution. How many know what that means? Right to a revolution. How many have the right to declare a rebellion? Right? How many of us? And political philosophy. Thank you, Queen. The right of revolution or the right of rebellion is the right or duty of a people to alter or abolish a government that acts against their common interest or threatens the safety of the people without justifiable cause. When you read this definition, think about what's going on in the government today and any government of the states of the United States in regards to if they have the right of revolution or do they have the right of rebellion. Okay? And it states that the right of revolution or the right of rebellion is the right or the duty of the people to alter or to abolish a government, that means the body of politics, that acts against their common interests or threatens the safety of the people without justifiable cause. Stated throughout history in one form or another, the belief in this right has been used to justify various revolutions, including the American Revolution, the French Revolution, and every other revolution that's underway. Okay? If everyone understand that, please give me a thumbs up in the chat if they understand the right of revolution. Once we understand the right of revolution, we can go to the age of revolution. Okay? Once we understand the right of evolution, we can go to the age of revolution and see where the age of revolution started from. Let me get a thumbs up in the chat. The age of revolution. This information should be front and center. The age of revolution, we know revolution means what? To overthrow. The word revolution means to overthrow. Let's go back to that. The word revolution means to overthrow. All right. Let's go to age of evolution. Age of evolution is a period from the late 18th to the 19th century, during which a number of significant revolutionary movements occurred in most of Europe and the Americas. The period is noted for the change from the absolute monarchy to representative government with a written constitution and the creation of a nation state. Once again, age of evolution. We looked at the right of evolution. Now we're looking at the age of evolution, where it came from, because the word revolution means what? To overthrow. The right to overthrow, or the justification to overthrow, whether it's by force of conquering, which would make it a justification for the reconquest of land that rightfully belonged to the owners. Okay? But when we talk about the age of overthrowing a government, it says it originated in the 18th and the mid 19th century, during which a number of significant revolutionary went underway. The period is noted for the change from the absolutist monarchy to representative government with a written constitution and the creation of a nation state. Boy, does that sound familiar. Doesn't that sound like your Revolutionary War, my brothers and sisters? Doesn't it sound like your Revolutionary War? The outcome of that was the Industrial Revolution. Okay? This is how you put the puzzle together. This is how you put the puzzle together. All right? So the right of revolution and revolution can be distinguished as well. The right of revolution and revolution can now be separated. We know that the word revolution means to overthrow. And we're talking about the right of revolution. Aside, have a seat. So we're talking about revolution and the right of revolution. The right of revolution is the right to overthrow versus revolution is just straight out overthrow without the right to do so. Okay? There is a big difference in the right to overthrow and just to overthrow without the right to do so. Let's get a prime example of just a straight overthrow other than the right to overthrow. Let's give those who were overthrown the right to overthrow it back. Okay? What they say, well, good for the goose, well, good for the goose is good for the gander. All right? Very, very, very important to understand that. Let's give a prime example we see here in the United States versus one Kim Bar. I know it. Yeah. Right. still on the topic of revolution. Before the revolution, the view of the publicist has been thus put by Vattel. Now, revolution means to overthrow, right? Versus the right to overthrow. The one who has the right to overthrow is the one who has the right to overthrow is the one who overthrows the one who overthrow who didn't have the right. Okay? So the one who had the right to overthrow, the one who didn't have the right to overthrow is what we call justification and necessity. Okay? There's a justification resulted from the conquest of land that was conquered by those who didn't have the right to conquer. Okay? So before their right to overthrow, as we see here in United States versus Warren Kmart, and United States versus Warren Kmart is the case law governing United States citizenship, governing subjects or citizens, as well as the inheritance of those subjects and those citizens, but it also touches on the right of immigrants, such as Warren Kmart. Okay? Warren Kmart was, in fact, an immigrant in the United States, called at that time, all right, of the America, called at that time, as a result of the revolution that was going on at that time, where it had nothing to do with citizenship or subjectivity, all right, based upon a oath of allegiance. It had to do with a oath of affirmation based upon the undertaking that was going on at that time, which was under the flag, which determined the oath of allegiance, everyone who would take allegiance to that new country based upon the standing or the status of those people, which had nothing to do with oath of allegiance but naturalization. Okay? So before the revolution, the view of the publicist had been thus put by Vattel. The natives or natural born citizens are those born in the country of parents who are citizens. We're talking about oath of allegiance, brothers and sisters, not based upon you being a naturalized citizen or being an immigrant. We're talking about oath of allegiance because this is the native land of your people. As a society cannot exist and perpetuate itself otherwise than by the children of the citizens. Those children naturally follow the condition of their fathers, okay, and succeed to all their rights. Society is supposed to desire this in consequence of what it owes to its own preservation. Allegiance, my brothers and sisters, and it's presumed as a matter of course that each citizen on entering into society, oath of allegiance, reserves to its children the right of becoming members of it, i.e., pledge of allegiance to the oath of the allegiance to the country, to the members in society of that country, to the heads of state of that country, okay, to uh, uh, the honorage and the prestigious of that country, okay. You have an obligation. The country of the father is therefore that of the children. So what your forefathers are, you are without doubt a contradiction. And these become true citizens merely by their tacit consent, which shall soon see whether on their coming to the years of discretion they may renounce their right and what they owe to the society in which they were born. Okay? So you have the ability to choose. Do you want to take an oath of affirmation based upon your newfound status or take an oath of allegiance unto your political status that was here before your butt was born? I say that in order to be of the country, the true bond which connects a child with the body of politics. We're talking about government. We're not talking about some land. We're talking about the government that's running the land, because why would you want to be on land without a body of politics like you see around the world? Israel, Iraq, it's nothing but chaos there. So that means that the body of politics has fallen. The true bond which connects the child with the body of politics is not the matter of an inanimate piece of land. I just said that. But the moral relation of his parentage. The place of birth produces no change in the rule that children follow the conditions of their father. For it is not naturally the place of birth that gives rights, but extractions. Okay? But extraction. The framers of the Constitution were familiar with the distinction between Roman law and feudal law, which is synonymous in my eyes between the obligation based on territoriality and those based on personal and invisible character of origin. And there's nothing to show that in the matter of nationality that they intended to adhere to the principle derived from the regal government, which was there prior to their existence, which they had just existed in a revolution. Okay? They said overthrow. I'm going to use the word revolution. Okay? The framers of your Constitution of 1776 didn't take an oath of allegiance. They took an oath of affirmation. 1 second, everyone. So as we can see, the framers of your Constitution, that would be your founding fathers, George Washington, and everybody on up till then. Your Constitution was founded on as a result of a what? A republic, revolution or revolutionary republic? Let's see that. A republic or a revolutionary republic? What is that? Let's see. We know that word means to overthrow. Revolutionary republic. Let's look at the term. Okay. We already looked at the right to revolution and the aids of revolution. Now I'm looking at the revolutionary republic, which we call Commonwealth. A revolutionary republic is a form of government whose main tenets, you hear that, are popular sovereignty, rule of law, and representative democracy. A revolutionary republic is a form of government whose main tenets, you hear that, main tenets, main holdings, main agenda are popular sovereignty, rule of law, and representative democracy. Okay? It is based on the idea of Enlightenment thinkers and was favored by revolutionaries during the age of revolution. Okay? A revolutionary republic tends to arise from the formation of a provisionary or temporary government after the overthrow of an existing state and political regime. It often takes the form of a revolutionary state which ostensibly represents the will of its constituents. I repeat, I repeat, your founding fathers of the United States, the representatives of the states and their citizens and immigrants as a result of the Republican revolutionary government that was set up, which means a government that was rooted in an overthrow, okay, is still functioning today by the ones who created it. A revolutionary republic, no matter what word you use, whether you want to call it a republic or a revolutionary government, whether you want to call it a republic form of government or a revolutionary government, it's still a government that was based upon an overthrow of the existing government, because the overthrown government or the revolutionary government or the Republican government or the Commonwealth government is provisionary based upon the overthrow, which is temporary, as we can see in the Jersey Bar statute, Title 52, colon 1-1. It's temporary. It often takes the form of a revolutionary state or colony or proprietary or what we call colony, state, uh, and whatever term you come up by based upon an existing overthrow. Okay? We see that right there. So the right of revolutionary is not the same as a revolutionary war, because the revolutionary war is a revolutionary war based upon an overthrow. Okay? All right. Not the right of revolution based upon the return of the government that was overthrown by those revolutionary, which we know was the founding fathers. How we know it is said it in the United States versus 1 Kimmel Art, which goes back to the case law and read it for ourselves. Who else teaches like this? The framers of the Constitution were familiar with the distinction between Roman and feudal law. Feudal law started with who? William the Conqueror. Between the obligation based on territoriality and those based on personal and invisible character of origin, and there is nothing to show that in the matter of nationality they intended to adhere. We know adhere means to follow to the principles derived from a regal government, which they had just assisted in overthrowing. All right, to overthrow a government, it must be a revolution. Yes, same thing they did in France. Same thing they did in France, Spain, uh, and on the Iberian Peninsula, and what we call the Maghreb. It was all based upon an overthrow or a revolution. Okay, we read it for ourselves. Manifestly, when the sovereignty of the crown was thrown off. All right, we're reading it for ourselves. And the independent government established, i.e., the revolutionary government, every rule of the common law in every statute of England, it didn't say Scotland, it didn't say Ireland, it didn't say United States, it didn't say America. It said every common law of every statute of England obtained in the revolutionary or the overthrowing colonies and derogation of the principles, i.e., the regal government, which the new government was founded on, was abrogated. Did you hear that? Was abrogated. The state, for all national purposes and intent, embraced in their revolutionary constitution, became one, united under the same autonomy, not sovereign authority, but a foreign autonomy, which was some type of authority based upon authoritative and governed by the same laws, but they retained their jurisdiction over all persons and things within their territorial limits, except what were surrendered to the general government or restrained by that constitution. And the protections to life, liberty, and property rested primarily with them. So far as the just commune and the folk right related to the right of the persons of the just commune, so far as the just commune or folk right related to the right of the person was concerned, the colony regarded them as what? Their birthright. Did you hear that? As their birthright. They're living off somebody else's birthright, which resulted from their Revolutionary War, which gives us the justification to create a Revolutionary War as well by lawful means. Okay? By lawful means. And hear that? By lawful means. When I say lawful means, I'm talking about the only means which can be done. That's the law. Any other manner you do it, it won't work. Did you hear that? It will not work. Why do I say that? Let's go here. I'm gonna have to do part 2 to this. Let's go here. Well said, Babylonian, not legal means. Embry versus Marsh. Embry versus Marsh. We're gonna look at 2 more cases before I close out. I'll do part 2 tomorrow. Okay? We're talking about oath of allegiance and oath of affirmation. Okay? Oath of allegiance and oath of affirmation. I'm gonna close out at 11:15. It's 10:48. I'm gonna go to 11:15. Okay? So y'all better get all y'all can with this information. Tomorrow I'll break this case down in regards to the party. Today I don't have time to do it. The oath of allegiance of the people of this county of New Jersey to the King of Great Britain. Hear that? It's found in Chapter 105, Allison Laws of 1776. Okay? Let's go New Jersey's Constitution. '21, '22, and '23. These are receipts, my brothers and sisters, from a king. Okay. 21, that all the laws of this province contained in the edition lately published by Mr. Allison shall be and remain in full force until altered by the legislature of this colony. Such only accepted as are incompatible with this charter, and shall be according as heretofore regarded in all respects by all civil officers and others and good people of this province. That the common law of England, as well as so much of the statute law as had been heretofore practiced in this colony, shall remain in force until they shall be altered by the future laws of the legislature. Should parts only accepted as are repugnant to the rights and privileges contained in this charter, and that the estimable right of a trial to a jury should remain confirmed as part of the law of this colony without repeal forever. That every person who shall be elected as aforesaid to be a member of the legislative council or the House of Assembly shall, previous to his taking his seat in council or assembly, take the following oath or affirmation. It didn't say oath or allegiance, it said oath or affirmation. When you read Embry versus Marsh, that case dealt with a case brought before the Chancery Court and then the Appellate Court and then the Supreme Court based upon um, a nominee for the Progressive Party for the governor of the 1949 elections in New Jersey. And it was based upon Chapter 21, 22, 24, and 25, which the Secretary, Attorney General, and some of the defendants in the matter moved for dismissal, and it was granted by the Chancery Court, but it was later appealed and it was granted reversal in the appellate court, which brought it before the Supreme Court. In regards to the unconstitutionality of the language in chapter 21, 22, 24, and 25 of the legislative enactment of 1949, which we'll read about in March limitedly, but tomorrow I promise I'll expound on it. Okay. Embry versus Marsh. In regards to the oath of affirmation and the oath of allegiance, which we know the difference of both now. Okay. Now we know what United States versus Lee said about the Stuarts severing the power and prerogatives of the crown. Okay, that's what it said. Now we're reading from Embry versus Marsh, a 1950 case from New Jersey. Okay, and this case right here is still applicable because we go by the 1947 Constitution. Excuse me. Who else studies like this? No one. Once I finish this lesson, I want everyone to give me their thoughts on today's lesson. Please, if you don't mind. oath of allegiance of the people Now, we say oath of the people, we're talking about the oath of allegiance and not an oath of affirmation for the people who become naturalized. Okay? Totally different. Okay? I know it's different. Let's look at the oath of allegiance statute, New Jersey Revised Statute 41:1-1. Let's look at the oath of allegiance. Okay? And it's going to expound upon it in the case law. This is the revised statute on the oath of allegiance. New Jersey Revised Statute 41:1-1, or English statute, oath of allegiance form. Every person who or shall be required by law to give assurance of fidelity and attachment to the government of the state shall take the following oath of allegiance. This is a statute, okay? This is a statute. So apparently there's a conflict between the statute we're reading and the Constitution of 1776, because it don't mention nothing about no allegiance, my brothers and sisters. So is this statute actually the statute of the state of New Jersey, part of the Union, or is this actually a statute enacted based upon the citizen or subjectivity of those who were subject to the laws of the Crown, now called reception statute, incorporated in the state of New Jersey, that we different from the Constitution of New Jersey in 1776? It is every person who or shall be required by law to give an assurance of fidelity and attachment to the government, body of politics, of the state shall take the following oath of allegiance. I do solemnly swear, or affirm, or affirmation. Okay? So you have an affirmation and a allegiance that I will support the Constitution of the United States and the Constitution of the state of New Jersey, and that I will bear the true faith and allegiance, there we go again, to the same and to the governments established in the United States and in the state under the authority of the people, so help me God. Did anyone hear that? Let's go back to New Jersey's Constitution and read Article 23. And everyone can see if y'all can read the hypocrisy. That every person who should be elected as aforesaid to be members of the Legislative Council or House of Assembly should previous to his taking his seat in Council Assembly take the following oath or affirmation. I, A.B., do solemnly declare that a member of the Legislative Council or Assembly, as the case may be, okay, of the Colony of New Jersey, I will not assent to any law, vote, or proceeding which shall appear to me injurious to the public welfare of the said colony, nor that shall annul or repeal that part of the third section in the charter of this colony, which establishes that the elections of members in the Legislative Council and Assembly should be annual, nor that part of the 22nd section of said charter respecting the trial by jury, nor that shall annul, repeal, or alter any part or parts of the 18th or 19th section of the same. And any person or person who should be elected as aforesaid is hereby empowered and to minister to the said members of the said oath or affirmation, provided always in its true intent, a meaning of that body of politics or that government that you call Congress, which consists of the Senate and House representatives, that if a reconciliation between Great Britain and these colonies, not the Kingdom of Great Britain, not United Kingdom, but Great Britain, which we call Kingdom of England, should take place, and the latter, the colonies, be taken under the protection and government by the apostles of the Crown of England, i.e., Great Britain, this charter should be null and void, otherwise to remain firm and inviolable. Now, there's no oath of allegiance here. There's an oath of affirmation for the office, but there's no oath of allegiance to the government or to the head of the government. Okay? So that distinction must be made. When you go back to Embry versus Marsh, and you read what the Supreme Court says about oath of allegiance, as we read in 41:1-1 of the Georgia Revised Statute, when I'm pretty sure no one has taught the oath of allegiance of the people, not the legislature, not the Senate, not Congress, not the agency, not the municipalities, but the oath of allegiance of the people, not immigrants, not foreigners, but the people, the English people, living in a territory identified by them as the colonies, subject to the King of Great Britain, as we recorded in Chapter 105 in House and Laws in 1776, which is read on the website, state that I agree with the majority as to the vices. You know, when we say vices, we know what that means. So they said, or the case said, I agree with the majority as to the vice of the oath as an invasion of the freedom of consciousness and expression and religion. I do not agree that the vices inherited therein are authority for the exclusive nature of one oath incorporated in our Constitution. That speaks volume. So they already agreed that there are inherited vices and the expression in the Constitution by the ones who founded the Constitution, outside of the original limitations put forth by the Constitution as it was inherited. Because we know corporate powers derive their authority from their sovereign grant. It's usually derived in the city or state or county where that corporate entity came into existence under that state law. And that state law would not be this Constitution. It would be the statute which we just read. Okay? Because the statute said a allegiance in 2025 for the people. And the power is in the people, and they're there to serve the people, so it must be uniform. Nor do I agree with this oath was given in any real force by Article 21 of the Constitution of 1776, adopted July 2nd, 1776, and the Declaration of Independence, adopted July 4th, 1776. We just read it. We just read it. So we can see that there are vices in the Constitution of 1776, as stated in Article 21, 22, and 23, because they were now rooted in the common law of England. Okay? How we know it? Because there was no oath to the British monarchs. There was no oath to Great Britain or the Kingdom of Great Britain. There was only an oath to Great Britain or the Kingdom of England, which did not reconcile until I came back. How we know it? Let's read. Excuse me. From either of these dates, from July 2nd or July 4th, 1776, there is no language in regard to an oath of an allegiance, all right, in that Constitution. We just read it. But we see it in the New Jersey Revised Statute 41:1-1 in 2024. Okay? So there was some type of allegiance in the state of New Jersey or the colony of New Jersey, all right, as a result of that statute, which we're going to read in brief versus March in a second. It says, from either of these dates, the oath to the British crown was without efficiency. We know what efficiency means, right? It was without efficiency because ours became a revolutionary government insofar as an allegiance to the British government was concerned. I repeat, we just read the statute 41:1-1. I'll read it again, show you again. In the oath amended by Law 1949, Chapter 21. They issued the chapter in that case to Chapter 21, 22, 24, and 25. This is Chapter 21. Every person who shall be in the government shall take an oath of allegiance. We didn't see the oath of allegiance in their charter. Okay? We didn't see no allegiance in their charter. There was no oath in that charter. So as a result of their revolution. All right? You don't give an oath when there's a revolution. So the object of a revolutionary is to break the oath. All right? As a result of the overthrow of government. We call that dissent. Okay? Causing dissent in the government. So as we can see here, every person who should be required by law to give assurance of fidelity and attach to the government of the state shall take the following oath of allegiance. Okay? The following oath of allegiance. They're talking about persons. We ain't even talking about the people. They're talking about persons. So that means they're talking about those officers who are there to serve the people. Because it said, I do solemnly swear or affirm through your affirmation that I will support the Constitution of the United States and the state of New Jersey, and I will bear true faith and allegiance to that body of politics established in the United States and the state, meaning they're uniform, autonomous, and one and the same under the authority of the people. Okay? The people took the authority from the king when you declared your revolution from the representative of God. Okay? We must understand the dilemma that the people are in. Let's go to Embry versus Mars. From either of these dates, July 2nd or July 4th, the oath to the British crown was without efficiency because ours became a revolutionary government. We know that a revolutionary republic is a result of an overthrow. So if the British crown is where you declare your independence from, okay, then there was no need for allegiance or oath of affirmation, which made the oath efficient deficient. Okay, it made it deficient because you became a revolutionary government. A revolutionary government is called a republican form of government or a commonwealth. Okay. Not only was the Continental Congress a revolutionary body, but the convention which adopted our Constitution was a revolutionary government. You hear that? Let's go back there. So it says, not only was the Continental Congress a revolutionary body, but the convention which adopted our Constitution was a revolutionary convention. So it's clear to say, it can be okay to say that it was a government based upon an overthrow. It was a convention based upon an overthrow. Okay, it's clear we can say that. From July 2nd, 1776, until the adoption of 1844's Constitution, it was submitted by the legislative executive, and judicial department of the government, and also by the people of the state as having force of a constitution. This is a historical fact of the matter, although I agree with the majority of the 1776 Constitution was deemed by the framers to be a statute, albeit an important statute of a type of Magna Carta, but nevertheless a statute amendable by the legislature created under it. Now we know the Magna Carta is what the United States used to declare their independence from a tyrant king. i.e., a revolutionary war, i.e., a civil war. All right? You use the Magna Carta to declare your independence, declare your revolution, declare your overthrow of the government of the king, which we know is a defamation per se. All right? To that king. All right? Not to that king because you have the right to overthrow with necessity, but that king they have a right to get you to create a defamation per se situation as a result of your oath of allegiance to your king. All right, because we know that what the Stuarts did in United States versus Lee, and what we see done in United States versus One Kim Ark of the founding fathers, you overthrow the government, both of y'all. So that is a direct result of what we're reading right here. I said, besides, Article 23, the Constitution of 1706 contains the following language, okay? Provided always in its true intent and the meaning of this Congress that if a rigorous relation between Great Britain and these colonies should take place, and that the latter be again taken under the protection and the government of the Crown of Great Britain, this charter should be null and void, otherwise remain firm and viable. So they understand that there was no efficiency in the so-called oath or allegiance or oath affirmation to the British monarch because they declared their revolution from the British monarch. But there was a statutory enactment or legislative enactment based upon a reception statute in that Constitution, which was an oath of allegiance, as we see in 41:1-1, which we see in the statute, that there was supposed to be a reconciliation with the Crown of England once the true king came back, which was the true representative of the monarch government, i.e., as Crown Corporation shows. Okay, let's see. But it said, at this late date, I do not think it is necessary to deal with the abstract question as to whether sovereignty, as to the sovereignty rested in those embattled moments in our history. The revolutionary government of the new nation and of the state consisted of the Continental Congress and the Articles of Confederation and our own revolutionary Constitution of 1776. But as we can see, the Constitution of 1776, the Constitution of 1844, the Constitution of 1791 or 92 of the United States, as well as the Constitution of 1947, all these constitutions are revolutionary constitutions, which are constitutions to overthrow the original charter or constitution that was already in existence. And we know that was, in fact, the Magna Carta. Okay? The Magna Carta. I'm about to close in a second. Let's go here. Lohman versus Lohman. All right? In closing. Part 2 will be tomorrow. Lohman versus Lohman. Now, this is New Jersey Superior Court, Appellate Court Division. We just read from Superior Court, Supreme Court. Now reading what the Appellate Court says. So anything the Appellate Court say, the Supreme Court gonna back up, okay? All in regards to our oath of allegiance to support the laws of this land, to support the representatives of this land, to support the owner of this land, and that will in fact to be the king and his representative. Okay? The king and his representative. In closing, Loman versus Loman states that the common law of England prevailed in the colony of New Jersey and is not open to question. Did you hear that? It's now open for questions. The settlers of the state brought with them the common law of England and such of its statutes as were of general application. It didn't belong to you, but you used it. On April 15, 1702, the properties of East and West Jersey made a full and unconditional surrender of the right to self-government to Queen Anne in 1702. It was called Queen Anne's government. It was called His Majesty's Council government, i.e., under the Kingdom of England. Anne accepted surrender and appointed Lord Viscount Cornbury as governor of the combined provinces. Under the new system of government, the citizens of New Jersey claimed the protection of and were subject to the same laws as any other British subject. So there was a difference between a British subject or citizen or an English subject or citizen. We know that the colonists who were not British or English subjects or citizens broke away from the British as a result of the feudal laws that were implemented as a result of the origin of where they stemmed from, which resulted from their affiliation with the Tudor branch, i.e., Henry VIII, as well as the Scottish branch, Queen Elizabeth I and Queen Bernadette, as well as Louis VIII from the Capital dynasty, all in conflict with the Angevin, Plantagenet, Lancaster, and York branches that descended down from Godfrey the Fifth, Count of Anjou, son of Foe, all of our peerages. Okay, so it says the common law of England and the statute of England, which were general in application. The colonial government could, under its charter, enact laws or ordinances to govern its inhabitants, subject to the approval of the crown, and so far as those laws did not abrogate the English law. So we see here in the Appellate Court in 1958, under the authority of the 1947 Constitution, still honor the oath of allegiance to the monarch or the laws of the monarch who governs the country, okay? And his position or tenure is representation of the crown. This provision must have been designed to ensure the crown that the laws of England having general application will be uniform throughout the empire. So England was an empire before it became the British Empire. Do you see what y'all seeing through my eyes, brother and sisters? Do y'all see what I'm seeing through my eyes? The colonial power to legislate was limited by charter. Remember, let's just go to it. Let's just go to it. Leeds versus Harrison. Leeds versus Harrison. Supreme Court of New Jersey. Corporate powers have their origin in a sovereign grant. Generally, they are derived from the Articles of Incorporation. Charters are derived from the Articles of Incorporation. So once again, your Articles of Incorporation is your charter. Majorities of your charters that you are called Articles of Incorporation did not derive from a sovereign grant because corporate powers have their origin in a sovereign grant. That meant that the grant must have been from that sovereign, whoever was the sovereign. Okay? Once again, corporate powers have their origin in the sovereign grant. Generally, they are derived from the Articles of Incorporation and the laws of the state under which the corporate body came into being. A corporation has those powers which are implicit in the charter as well as those which are expressed. Authority not reasonably within the corporate grant is excluded. but whatever may be fairly deemed an incident of the power expressed conferred by the charter or corporate certificate of corporation within the grant unless expressly are prohibited. The instrument is to receive a reasonable construction to serve the general application based upon the charters of the certificate of corporation bill. That also brings me to Chisholm versus Georgia. In regards to the corporate powers derived their origin from the sovereign grant, which is the one who creates the corporation based upon the grant, which in fact would be the king. Okay, let's go ahead. Chisholm versus Georgia. The only common law concerning corporations to which I conceive the least references to be had in the common law of England on that subject. I need not repeat the observation I made in respect to the operations of law in this country. The word corporation, in the larger sense, has more extensive meaning than people generally are aware of. Anybody politics, sole or aggregate, whether its power be restricted or transcended in the sense is a corporation. The king accordingly is a corporation, and so by very respectful author is Parliament itself, uh, as well as the state singly, as well as the United States also return a corporation. Okay, and it clearly goes on to say that kings create corporations. So back to Lohan versus Lohan in closing. The colonial government can, under its charter, enact laws or ordinances to govern its inhabitants, subject to the approval of the crown, insofar as those laws do not abrogate the English law. These provisions must have been designed to ensure the crown that the laws of England, having general application, will be uniform throughout the empire. The colonial power to legislate was limited to the charter provisions of the enactment laws that were deemed peculiarly essential to their local condition. This legislature were not empowered to change the law of England, save by special approval of the crown. Thus, in 1702, the common law of England and those statutes were given general in nature were applicable in New Jersey. See the case law supporting that. Moreover, there are special reasons why title to real estate, not real property, title to real estate, all right, and the right, benefit, and duties flowing from such ownership should be governed by the common law until modified by legislative enactment. It is requisite to a well-ordered society that there will be stability and certainty in the laws regulating these rights. And it is imperative to such a society that some know law by to be know the law be applicable. I surrendered to Anne, and until the passage in England of the statutes of Queen Anne, the common law of England was a law which governed the rights, privileges, and duties which concerned the courts, in this case, Camden Trust Company and Handel. So, in closing, if you think that you have an estate here in North America, all right, as part of your birthright, as part of your both birthright, then you must show your allegiance to your ancestors, who were not just kings and queens, they were earls, dukes, nobles, etc. You must follow in their footsteps. Okay? You must follow in their footsteps. So once again, the revolution is real, brothers and sisters. It's just what side you're going to take concerning that revolution. Okay? Are you going to keep overthrowing? Are you going to help restore by overthrowing who keep overthrowing your right to overthrow? Okay? Or your right to revolution? Once again, the right to revolution is the right to overthrow those who overthrow your government without that right, okay? And those are ones who were the founders of the revolution, which started, as I said, in the 18th and the 19th century. So with that, this ends this lesson, part one. Part two will probably be tomorrow or the day after, possibly Sunday. I have a little bit longer time to share with you, but I hope you understand that the American Revolution is in fact the key to breaking our understanding of how we became slaves in America. Okay? So watch this one as well as the last couple that I did, and I'm pretty sure that your understanding will raise to the highest degree. And with that, I'm going to leave you as I always greeted you, as in peace and love. Peace. Are there any questions before I leave? Are there any questions before I leave? Please ask them now. Are there any questions before I leave? Please ask them now. Thank you, Brother Nonly, for showing up. Thank you, Brother Nagara, for showing up. Thank you, Archbishop Belmont, for showing up. Thank you, all those who were present today but didn't leave their name. Thank you very much. My job is to make sure that I do my best to enlighten you when there's a chance you can in fact be enlightened. With that, I'm gonna leave you as I greeted you. That's in peace.